My name is Jeff Morgan. I'm from Dallas, Texas. And to continue on with the findings of the court in the matter Georgioulis versus Younger, DF-15-09887. This was rendered by Judge Kim Cooks of the 255th Judicial District Court. The memorandum ruling for the final trial that took place October 15th to the 21st, 2019. And by the way, in case there's any questions, Mr. Younger did not give this order to me. I did get it from somebody else, but Mr. Younger is under a gag order, and I believe that that gag order is unconstitutional. Something to consider with regard to this gag order is that very recently, the Office of the Attorney General wrote a brief for the state of Texas as amicus curiae regarding the issue of a gag order, and this was pertaining to another individual. This was filed October the 18th, 2019, and again, this is referring to a gag order that was placed upon somebody. But the summary of the argument is like this. The gag order is a prior restraint on speech. It is plainly overbroad and cannot be squared with the First Amendment's free speech guarantees. There is nothing that prevents the trial court from correcting its erroneous gag order, which clearly contravenes constitutional free speech guarantees. So the argument continues on as follows, that gag orders are prior restraints on speech. Gag orders restrict access to information by prohibiting individuals from discussing a case. Prior restraints on speech and publication are the most serious and least tolerable infringement of First Amendment rights. As such, gag orders are presumptively unconstitutional and entail a heavy burden on the state actor to prove otherwise. A constitutional gag order is the exception, not the rule. So if there is a gag order that is placed upon Mr. Younger, I believe that Judge Kim Cooks should actually present the reasons as to why the gag order should be placed upon him. Because gag orders are presumptively unconstitutional and entail a heavy burden on the state actor, which would be in this case Judge Kim Cooks, to prove otherwise. I have not seen the proof that the gag order should be on there. From the documents I have and from what I've heard, I have not seen any proof that the gag order has any support, any legitimacy, and that it is not an infringement on Mr. Younger's First Amendment free speech guarantees. With regard to this other order, it talked about how the order was plainly unconstitutional and what it did as far as restricting the speech of these individuals. The First Amendment prohibits state action abridging the freedom of speech. That is the First Amendment. Protection against prior restraints on speech is at the core of the First Amendment. Prior restraints are disfavored because by definition they have an immediate and irreversible sanction. A court must balance the First Amendment interests infringed by preventing the speech against the interests protected by preventing the speech. The substantive evil must be extremely serious and the degree of imminence extremely high. The order cannot speculate as to the effect of the speech. Any speculation, that doesn't make a difference. It means nothing. The order must be clear. The order must be couched in the narrowest of terms that will accomplish the pinpointed objective permitted by constitutional mandate and the essential needs of the public order. A state actor does not demonstrate adequate justification merely by asserting certain speech is the invasion of privacy or that it disseminates inappropriate information. Further, a state's interest in protecting juveniles cannot alone justify suppressing speech about a juvenile's private information that was lawfully obtained. The broad powers of Texas family trial courts do not authorize them to invade constitutional guarantees. And I could continue on further with that, but just to make my case that I believe that the gag order, as well as many other practices that take place in our family courts, do violate constitutional guarantees. I am very pleased to see that the Office of the Attorney General has written this brief for the state, and that they've taken the position that they have. So perhaps between this brief and the opinion that the Attorney General rendered in February, KP-0241, maybe we can start to clean up the swamp in our family court system.